Can scientists create a new life form? It sounds like a question for a biologist, or maybe a philosopher. But can someone invent and patent a life form? That's a legal question which went to the Supreme Court and made headlines around the world. I'll be giving context to some real audio and video clips.
Next, in Diamond, the Commissioner of Patents against Chakrabarty.
Ananda Chakrabarty was born in West Bengal and got his PhD from the University of Kolkata. After a postdoc at the University of Illinois, Chakrabarty moved to General Electric's research lab in Schenectady, New York. In 1972, Dr. Chakrabarty was experimenting with UV radiation to combine plasmids from multiple bacteria strains. The new strain of bacteria could help break down harmful chemicals after an oil spill. This wasn't even his primary task. On weekends and evenings, he studied the pathways to degrade hydrocarbons in Pseudomonas. Ananda was eager to share this work, but his bosses wanted to secure a patent first.
I had planned to give a talk about these pathways in a meeting in Tel Aviv, but Vice President Dr. Arthur Bicker, who knew me because of my weekend visits, suggested that I apply for the patent first.
The application went to GE's attorney, Leo Malosi, who grew up in Albany, fought in World War II, and returned home to finish an engineering degree and then law school. At this time, the U.S. Patent Office would accept a patent on the process of making and inserting the plasmid, but not a patent on the genetically modified organism itself. This helpful bacteria looked like the perfect example to challenge that policy. The legal and appeal process took 8 years, but ultimately the decision went up to the Supreme Court in 1980. Both lawyers decided to tell the same story, the history of U.S. patent law, but with different takeaways. The earliest known biotech patent was already 100 years old. In 1873, Louis Pasteur, yes, the pasteurization Pasteur, had received a patent for manufacturing disease-free yeast for beer and baking. Lawrence Wallace, representing the Patent Office and its Commissioner Sidney Diamond, would take 157 cases to the Supreme Court over his career. He argued that Pasteur was consistent with patents only on the process, not the living yeast itself.
There was a patent issued to Pasteur for an apparatus and method of purifying yeast, and that included a claim on the yeast so purified, without mentioning any specific strain.
Edward McKee Jr. was a New York patent attorney with decades of experience. This was his first and only Supreme Court appearance. He argued that Pasteur and dozens of old patents proved that life forms were already fair game at the Patent Office.
We brought forward several different kinds of evidence which do show that the policy of the Patent Office in the past has been to grant patents on living subject matter, in addition to the number of patents that we have identified and also the cases that we have referred to. We've pointed out that the Patent Office has established official classifications of patents on living things. The reason being, of course, that they have sufficient number of patents that they want a place to put them.
Admittedly, Justice Blackmun would cut that list of old patents down to just 3 examples which were not a combination, but possibly a patent solely on one life form.
But when we confine ourselves to claims that cover only the living thing, they say only 3 out of your 68 patents involve such examples.
But McKee pointed out that some patents added very little. They were essentially bacteria patents.
Because several of the claims in this case, the allowed claims, cover the combination of a bacterium with a carrier, namely straw. That bacteria is not found in straw in nature, therefore it is not a product of nature, but it's still alive.
Moving forward in history, in 1930 Congress passed the Plant Patent Act. This expressly allowed certain types of plants to be patented by breeders. Farmers quickly filed patents on new hybrids, such as varieties of apples. You can look these up. They have a lot of sketches of apples in there. Now, did it make sense for plants to be patentable and not bacteria? The Patent Office argued Congress was recognizing that life generally was not patentable, and they needed this law to be added. They also excluded categories of plants such as tubers, which meant that the norm was that plants were also not patentable.
Congress was not operating on the premise that any distinct and new variety of plant was a category already included within any new and useful manufacture or composition of matter.
They included a letter sent to congressional committees of the time from President Hoover's Secretary of Agriculture, Arthur Hyde.
We've set forth this letter on pages 24 and 25 of our brief, stating very specifically that the purpose of the law is to bring the reproduction of newly bred or found plants under the patent laws, which at the present time are understood to cover only inventions or discoveries in the field of inanimate nature.
The Chief Justice Warren Burger asked about the wording of the letter.
What significance do you place on what would appear to be very carefully chosen words that at the present time are understood to cover, are understood? If there were holdings that were perfectly clear, he wouldn't have used that language.
Well,
Justice Stevens also chimed in.
If you were looking for an expert in the patent laws, would the Secretary of Agriculture come to your mind right away?
On the other side, McKee argued to dismiss the Secretary's letter.
That letter is relied upon by the congressional committees for the expertise that the Agriculture Department has in identifying varieties of plants, and they are suggesting that the Patent Office may want to come to them for assistance in distinguishing between the various varieties of plants.
On the 1930 Act, Justice Stevens asked what use it would have if McKee was correct.
If this case had been decided in your favor before 1930, that statute would have been unnecessary. Do you think that is a correct, would that be a correct argument?
McKee points out that it helps plant breeders because previous patent standards require the text to make it completely reproducible.
The requirements of the patent law, then and still today, except for plants, required that you describe the invention sufficiently that it could be reproduced. And you can't describe a plant sufficiently that it can be reproduced. So what happened in 1930 was that the Congress put in a special exception for plant patents and said, you don't have to comply with that.
The first major challenge to patentable bacteria had come in 1948, the Supreme Court case Funk versus Kalo. Kalo & Co. sold a package of multiple strains of Rhizobia bacteria, which they patented in 1938. These bacteria help plant roots collect more nitrogen from the air. This is an organic fertilizer technique which they continue to sell today. Funk Brothers sold a similar product, so Kalo invoked their patent and lost. The 1948 decision relied heavily on Kalo's product being something found in nature. Though it was revealed by science, they were not the inventors of something new. Had Dr. Chakrabarty done something fundamentally new by adding a gene through a plasmid, would this be an exception? When the patent was first filed, Congress had just returned to plant patents with support for the remaining plants in 1970, and just plants.
And when the Plant Variety Protection Act was enacted, it contained a specific exclusion for bacteria.
In a final rebuttal argument, Wallace argued for the Patent Office that if there were a patent on any organism, that would mean that all of its offspring would be infringing on the patent, something which was supposed to be protected for farmers in the 1970 Act.
It is an unprecedented extension of patent monopoly to the biological offspring of living organisms. And Congress has very carefully controlled this in the Plant Variety Protection Act.
Chakrabarty and General Electric won, but in a narrow 5-4 decision. The majority decision made very broad statements, including bringing this 1952 quote to the forefront, "Anything under the sun that is made by man." That means that Diamond versus Chakrabarty continues to be cited in patent cases on genetics, business processes, software, and even a dispute between Samsung and Apple on smartphone patents. 4 justices dissented, including civil rights legend Thurgood Marshall. These 4 did not speak much during oral argument, but their dissent follows most of the government's arguments. They noted that bacteria were specifically excluded from legislation and recalled a case from just 2 years earlier, Parker versus Fluke, which had warned, proceed cautiously when we are asked to extend patent rights into areas wholly unforeseen by Congress. By the time the Supreme Court case and patent were finally scheduled, Dr. Chakrabarty had moved on to work at the University of Illinois Medical Center, where colleagues called him AMC, or Al. A year later, he was in the newspaper for a new bacterium, this time one which would decompose chemical weapons, such as Agent Orange in Vietnam. A few years later, a team at Harvard University filed a patent for the Oncomouse, a lab mouse genetically engineered to be more likely to develop cancer.
The Supreme Court had just decided that life forms could be patented. And as an obedient employee of Harvard Medical School, Tim and I, reported this invention.
When it was approved in 1988, it was the first patented mammal and essentially opened patents to every animal except humans. Though Diamond v. Chakrabarty is the main case which you would cite as precedent, the jump to mice was much more shocking to the public, now that they had more knowledge and new fears about bioengineering and mutations. In 2002, Canada's Supreme Court ultimately rejected Harvard's Oncomouse patent, and it continues to be impossible to patent higher life forms in Canada, though patents still exist for the process. In 1989, there was an oil spill in Alaska's Prince William Sound.
Not only the worst oil spill in U.S. history, it's by far the largest in such a remote, pristine area.
A journalist called on Chakrabarty to see if the bacteria was ever made available. He explained there was a fear of contamination with the new genes.
I've had a couple of people ask a question, why was your genetically modified organism never used? And do you know why hasn't there been a commercial product like it to clean up oil spills?
The problem at that time was that there was a lot of fear, rightly or wrongly, about what the genetically engineered microorganisms can do. The problem was we couldn't definitely argue that these plasmids cannot be passed along to other microorganisms that were pathogenic because we had no data and plasmids can be transmitted.
In the early 2000s, Dr. Chakrabarty founded companies which search for uses of bacteria to treat cystic fibrosis, cancer, and other diseases. One of those products, named P28, completed a phase 1 clinical trial. In 2014 and 2017, he co-authored 2 works of speculative fiction, which revolve around treating cancer with bacteria. In June of 2020, the Smithsonian and George Mason University held a virtual session to commemorate the 40th anniversary of Diamond v. Chakrabarty.
I hope human ingenuity is always rewarded and patents are used to improve the quality of life. Thank you for listening.
Dr. Chakrabarty passed away later in the summer of 2020. He was honored by the University of Illinois as obituary appeared in Nature Biotechnology. I appreciated this description of what it was like to work with him. Cheerful and easygoing, the quintessential example of a professor who loved to teach, an inventor who moved humankind forward, and a scientist who genuinely cared about the technology to solve pressing societal problems. This was an unusual video for the channel, but I think it relates to the history behind the biology and genetics topics that I've talked about before. If you like, comment, or subscribe, that does a lot to help out the channel. Thanks for watching.